Greetings from the University of Tasmania in Hobart, and welcome to this wonderful conference on Asia-Pacific Perspectives on International Humanitarian Law. I'm really sorry that I'm not able to be with you to speak in person at the conference, but I hope that you're all really enjoying your interactions with each other and the great presentations that you're hearing. I'd like to offer my congratulations to the co-organisers of the conference, firstly to Zhejiang Gongshang University, to the Beijing delegation of the International Committee of the Red Cross, and particularly to my dear friend Susanna Linton, without whose tireless efforts to organise the conference, none of us would be able to enjoy the gathering together. When Susanna first approached me about the 70th anniversary of the Geneva Conventions this year and how we could mark them by publishing a collection of essays on voices from the Asia-Pacific region on international humanitarian law, I was delighted to accept the invitation that she offered to join with her in that enterprise. And so I'd like to congratulate both Susanna and Sandesh, our third co-editor, for the wonderful privilege of working on this great project together. And again, I'm really sorry that I'm not there in person to launch the book. When I think about the Geneva Conventions and this milestone anniversary, the 70th anniversary, of course, there have been many celebratory events around the world, particularly focused in Geneva, where the International Committee of the Red Cross is based, marking not only the 70th anniversary of the Geneva Conventions, but also this year, coincidentally, the 150th anniversary of the International Review of the Red Cross, the oldest and arguably most prestigious publication in English on international humanitarian law, consistently published from Geneva. It's a great contribution the institution has made. But of course, as we reflect on the Geneva Conventions and their significance for international humanitarian law, these are the pillars of the body of law, of the legal framework that applies in the context of armed conflict. And both Susanna and Sandesh and I are of the shared view that too much of the voices in the academic literature, at least in English, are from Western Europe and from North America, and not enough is heard on a regular basis from scholars in our part of the world. And so all of us are thrilled with the outcome of this particular volume, which really does give voice to different perspectives on the important area of law that we cover. When we talk about the Asia-Pacific region, we're talking about a region which is, of course, incredibly diverse. We're talking geographically from South Asia, India, Sri Lanka, Bangladesh, Nepal, Pakistan, all the way east through Southeast Asia, Indochina, up into the eastern part of Asia, particularly China, Japan, Mongolia, the two Koreas, and of course the Pacific, Australia and New Zealand, and out into the Pacific Ocean, right across the international date line heading east to Samoa and to Tonga, which straddle it either side of the date line. When we think about the countries that the region encompasses, there is incredible diversity. I made the observation in the introduction to our volume that 5 of the 10 most populous nations on Earth are in this particular geographic grouping, but so also are 4 of the 10 least populous. So on one hand, we have China and India, which combined have 40% of the world's population. And we also have Nauru and Kiribati, which between them have just over 20,000 people. So there's incredible diversity in terms of size of populations, but that level of diversity is overshadowed by much greater diversity when we think about culture, language, ethnicity, legal traditions, music, food, I mean the whole range, the panoply of what makes us who we are as human societies. And we celebrate that diversity by wanting to bring as broad a range as possible of voices from the region to talk about international humanitarian law. Of course, when you start out with a project that focuses on what a region has to say about a body of law, then we are contemplating the fundamental importance of place, of physical place, to the story or to the perspectives that are being brought to bear. And I've thought about 5 different aspects of what place in the Asia-Pacific region means for international humanitarian law. First of all, and perhaps a rather obvious starting point, is to identify those cultures and societies in this physical part of the world, this geographic part of the world, that have contributed to the development of the concept, the humanitarian concept of constraints on the waging of war. And even in the Western world, it's well known that both Sun Tzu's Art of War and Manu's Smita, the code of waging of war from Hindu civilization in India, were both major early contributors to the growing concept that constraint on the waging of war is important from a strategic military perspective as well as important from a humanitarian perspective. But I think it's true that in Western traditions, it's easy to simplistically refer to either Sun Tzu's great writing or to Manu's code as examples of the emergence of a concept of constraint on the waging of war without going in any significant depth into the nuances or details of what those 2 writings really mean for early emergence of concepts of humanitarian constraint in war. And we fortunately have in this volume of essays 2 really wonderful chapters, one each on those 2 ancient writings that help overcome the tendency to be overly simplistic in our analysis of what they both mean and the constraints that are contained within them. I think that's a really great place for us to start, even if, as I said earlier, it's perhaps a predictable place to start. Because no one would suggest that only the Asia-Pacific region contains ancient civilizations which encapsulate or incorporate within their traditions constraints on the waging of war. That's also true in ancient Greece, in ancient Rome, in ancient Egypt, in other ancient civilizations in other parts of the world. So a second aspect of what place in the Asia-Pacific region means for international humanitarian law is the concept that here, in this part of the world, there were a number of cataclysmic events, of major armed conflicts and events that occurred within those conflicts that really influenced the subsequent development of this body of law. So, I mean, if we think about that for a few minutes, for example, it is in this part of the world where nuclear weapons have been used in war in the only occasion where that has occurred in the history of humanity. It's in this part of the world where the overwhelming majority of the testing of nuclear weapons, both atmospheric and subsequently underground testing, have occurred. And there are a number of locations around the region where that's happened in the past, and in North Korea's case, where it's happened in very recent times. In addition, when we think about World War II, in this part of the world, there have been systematic or allegations of systematic crimes of sexual violence, torture of prisoners of war, summary executions, pillage, and also saturation bombing of cities. And it's really important for us as we think about the Geneva Conventions themselves and some of the rules applicable to under Geneva Convention 3, for example, to the protection of prisoners of war, or Geneva Convention 4 in relation to the protection of civilian populations that find themselves subject to foreign military occupation, that we acknowledge some of the contributions that events in World War II in this part of the world have made to the subsequent development of those treaties. But in more recent conflicts than World War II, the conflict on the Korean Peninsula in 1950, the Vietnam conflict in the 1960s and early 70s, Cambodia in the 1970s and Laos around about the same time, and then multiple conflicts since then in different parts of the Asia-Pacific region. If we think about some of the uses of particular categories of weapons in those conflicts, think about the extensive use of defoliant agents in Vietnam and the important recognition in subsequent development of the law on the protection of willful infliction of long-term severe and damage to the environment, for example, or the use of napalm and other incendiary weapons leading to the prohibition in Protocol 3 to the 1980 Certain Conventional Weapons Convention on incendiary weapons used against civilians or civilian property. Think about the rise of guerrilla warfare and the emergence of non-state armed groups, something that was observed during the Vietnam War, but also subsequently in other conflicts in all sorts of parts of this region. We think about genocide and crimes against humanity in relation to Cambodia, and more recently allegations of the same thing in respect of the Rohingya from fleeing from or forced to flee from Myanmar into neighbouring Bangladesh. The widespread use of anti-personnel landmines, the emergence of insurgencies and questions about when an insurgency crosses the threshold to become a non-international armed conflict and the law that applies as a consequence of that. We think about this long and terrible, often deleterious history of armed conflict in the Asia-Pacific region. Then we can see that on many occasions what's happened in this part of the world has contributed to the subsequent development of the law. So much of the making of international law, and this is true generally as well as it is for international humanitarian law specifically, so much of the making of international law happens in response to or as a reaction to major disasters or cataclysmic events. And that's certainly true of some of what's happened here. Although again, just as with pointing out the contribution from this part of the world of the development of ancient civilizations' approach to the constraining of war, of the conduct of war, we have to concede again that what's happened in this part of the world is not unique. And there are other regions of the world where one conflict after another have contributed significantly to the development of international humanitarian law. That's true for Western Europe and for Eastern Europe. It's true for the Middle East. It's true for Africa. It's true for Latin America and even North America back to the 19th century. A third example of place being significant for the development of international humanitarian law is in relation to regional approaches to the making of the law. And I know that Professor Sivakumaran is in his keynote address and subsequent presentation to the conference will touch on this very important topic. But one of the great things that he does in this volume of essays is identify the ways in which states from the Asia-Pacific region have taken particular positions on the negotiation of treaties, of international humanitarian law treaties, and also the extent to which states from this particular region have participated in, have signed on to and ratified or acceded to major international humanitarian law treaties. Again, not a unique aspect of what place, the significance of place for this particular issue about making of and signing on to international humanitarian law obligations, because you could make the same observations about other regions of the world. But there are some really significant things about what's happened in our part of the world and what it means for participation in international humanitarian law agreements and conventions and treaties. A fourth aspect of the significance of place is in relation to regional approaches to implementation and enforcement of the law. And there are quite a few chapters in the book which I think really highlight different national approaches to the question of the training of the military to ensure that that particular fighting body he is cognizant of, aware of, understands the importance of respect for international humanitarian law when deployed on military operations, whether those military operations are internal to the country itself or whether they're external in either peacekeeping operations or war fighting in other parts of the world. We also see in relation to enforcement, the enforcement of violations of international humanitarian law, some significant progress at the national level in some countries, and again there are a number of chapters that deal with how particular states in the region enforce the law for serious violations of international humanitarian law. There are also some interesting chapters about frustrations in relation to international efforts. So going beyond exclusive national jurisdiction to the question of international jurisdiction. We have some history in this part of the world, of course, in the immediate aftermath of World War II, where the Tokyo War Crimes Trial was set up subsequent to the Nuremberg Tribunal. And that experience has been very significant in several aspects in the development of international criminal law, particularly on the issue, I'd say, of command responsibility because of the approach that the Tokyo Tribunal took to that question. But we also know that there are ongoing criticisms from Tokyo as well as from Nuremberg about the victor's justice aspect of these two major trials, that the winning side set up a process for holding accountable individuals allegedly responsible for international crimes on the losing side of the war. And I think it's really important to acknowledge that the Tokyo War Crimes Trial has contributed not only to the development of the substantive international criminal law, but also contributed to a criticism of that particular mode of enforcement. It's inconceivable now that in the establishment of an international criminal tribunal or international criminal court, that it will be set up by the winners of a conflict imposed against the losers. That might happen at the national level, but it couldn't happen at the multilateral level because we as an international community have accepted that what happened then is no longer an acceptable model. So there's a wonderful chapter by Susanna Linton about the failure of the international community to deal with alleged war crimes in East Timor, for example. Also a very important chapter about the Cambodian experience, where the international community and the Cambodian government have established the extraordinary criminal chambers in the courts of Cambodia. And references also to the frustrations or the limitations of the jurisdiction of the International Criminal Court. So the International Criminal Court has recently decided to give the prosecutor the authority to investigate the alleged crime of forcible deportation of Rohingya across the international border into Bangladesh because Bangladesh is a state party to the Rome Statute. Myanmar is not. And the fact that Myanmar is not, and that the UN Security Council has been precluded from referring the situation in Myanmar to the ICC, means that the court can't look at any crimes wholly perpetrated within the physical territory of Myanmar. The only reason the court believes it has jurisdiction over forcible deportation to Bangladesh is because, coincidentally, Bangladesh happens to be a state party and as a consequence, a state party to the Rome Statute. And as a consequence of that, the court has territorial jurisdiction over what occurred on the physical territory of Bangladesh. Again, we could make similar observations about other regions of the world, some states doing a very good job, an exemplary job, of the use of national jurisdiction to enforce violations of international humanitarian law, and other frustrations and limitations on the exercise of jurisdiction by international criminal courts and tribunals. I think perhaps the fifth and final observation I'd make about the significance of place, particularly the Asia-Pacific region, are those on the development of international humanitarian law, are those aspects from the region that perhaps are truly unique. And here I think there are two chapters that are really wonderful contributions to this volume of essays. The first of them is by Professor Yeo Fanton, who is based at the Australian Defence Force Academy in Canberra. And I'd like to read what I wrote about her contribution to the volume in the introduction to the book. Professor Yofantong recognises the importance of identifying and tracing the sources of a commitment to humanitarianism more generally than international humanitarian law, as integral to explaining why international humanitarian law might be more readily accepted or ignored in this particular part of the world. Her chapter on the origins and evolution of humanitarian action in Southeast Asia, focusing primarily upon examples from Myanmar, Thailand and Vietnam, explores the influence of faith and culture on the notion of humanitarianism in the region. Professor Yofantong identifies and analyses nuanced differences in various states, and in some cases amongst ethnic communities within states, and concedes the inevitability of political imperatives which undergird any humanitarian action and which guarantee granularity of difference. Intriguingly, though, she warns against overlooking regional commonalities in respect of humanitarianism, a commonality that derives from what she calls the notion of the interdependent self, or the communitarian ethic, a notion that emphasises the importance of social obligations and allows for people to identify the plight of others as somehow related to their own. For those committed to identifying and understanding moral and cultural obligations as a potential means to influence more effective implementation of legal obligations, especially international humanitarian law obligations in the context of armed conflict, this notion is surely worthy of much more detailed study. Here we have a chapter, and there are others that are relevant to this same concept. We have a chapter that they're about the very uniqueness of attitudes and approaches, of worldviews, of aspects of faith and of life in this part of the world that might be truly unique about how countries in this world view their international humanitarian law obligations. I'm fascinated by that concept and deeply indebted to Professor Yofantong for introducing it to us. Thank you again for the privilege of being involved in the conference, even though it's virtually by distance. And I hope that the rest of your time is very productive and encouraging. Again, I thank both Professor Linton and Professor Sivakumaran for the deep privilege of joining with them in the publication of this wonderful volume of essays. Thank you.